Good evening, everyone, and welcome to the 2017 Dean's Cup. My name is Christine Ume, and I'm one of this year's Dean's Cup coordinators. Now, before we get started, we just ask that in order to minimize the distractions to both the judges and the finalists, each individual turn off or silence their cell phones. We also ask that once the arguments get started, everyone remain seated and not exit the room. Finally, we'd like you guys to know that you are all invited to the Dean's Cup Finals reception happening after the arguments in the Star Commons mezzanine. The Dean's Cup is Duke Law's premier oral advocacy competition. Every year, 2Ls and 3Ls compete both in oral arguments and in brief writing for the opportunity to be considered among Duke Law's best appellate advocates. This competition could not happen without the assistance of many people. So we'd like to thank some of them. First, we'd like to thank Dean Levy. Thank you for your ongoing support of the Moot Court Board, particularly your support of the Dean's Cup. We appreciate it, and we hope to continue for the remainder of your time here. We'd like to thank Professor Sean Andrewser, our faculty advisor, who, among other things, crafted the problem, as he does every year, and it is taught in the fall in the appellate practice course for 1Ls and 2Ls that might be interested in that. We would like to thank Sarah Emily and Hannah David of the Clerkship Office, Liz Green and Laura Grisham of the Events Office, and all the admin and faculty members that assisted in judging or grading briefs. We appreciate how generous you guys were with your time. We'd particularly like to name those faculty members that were helpful at multiple junctures. So special thank you to Professor Thomas Metzloff, Professor Rebecca Rich, Professor Ernest Young, Director of Externships Ann Gordon, Professor Jane Weddage, Professor Lucia Oleknichkova, and Professor Marilyn Forbes. And of course, I would like to thank my fellow Dean's Cup coordinators, Chase Harrington, Bo Stewart, and Kareem Lakhani. This year's case presents a challenge to a punitive accommodation from the contraceptive mandate of the Affordable Care Act. The plaintiffs are two Missouri-based religious nonprofit organizations, CNS International Ministries and Heartland Christian College. Their challenge is being made under the Religious Freedom Restoration Act, or RFRA. RFRA provides that the government cannot substantially burden religious freedom or religious exercise unless that burden is the least restrictive means of achieving a compelling government interest. I will now introduce our finalists tonight. Representing the petitioners, the Department of Health and Human Services, we have Amelia DeGory and Ethan Wright. Amelia DeGory is a 3L from Pennsylvania. She received both her BA and her Master's in Education from the University of Pennsylvania. Ethan Wright is a 2L from Mercer Island, Washington. He received his BA from CNS College in Pennsylvania. The respondents, CNS International Ministries and Heartland Christian College, are being represented by Leah Brenner and Hope Staneski. Leah Brenner is a 2L from Kennett Square, Pennsylvania. She graduated from Franklin and Marshall College with her bachelor's degree. Hope Staneski is a 2L from Milford, Connecticut. She graduated from Bates College with her bachelor's degree. Finally, we'd like to introduce our esteemed panel of judges. Judge Jose Cabrenis of the Court of Appeals for the Second Circuit graduated from Columbia and Yale Law. He was appointed to the District Court for Connecticut in 1979 and was appointed to the United States Court of Appeals for the Second Circuit in 1994. Judge Jeffrey Sutton of the Court of Appeals for the Sixth Circuit graduated from Williams College and The Ohio State University's Moritz College of Law. He was a clerk for Thomas Metzko and Justice Antonin Scalia and was appointed to the Court of Appeals in 2003. Finally, we have Judge Algenon Marbley of the United States District Court of the Southern District of Ohio. He is a graduate of UNC Chapel Hill and Northwestern University School of Law. He made partner at the law firm Boyers, Satter, Seymour, and Pleas, and was appointed to the District Court of Southern District of Ohio in 1997. Without further ado, we'd like to begin the competition.
court is now sitting. God save the United States and this honorable court.
Good afternoon. We'll be hearing counsel in Department of Health and Human Resources et al. Versus CNS International Ministries et al. And we'll begin with counsel for the petitioner.
Mr. Chief Justice, and may it please the court, my name is Ethan Wright, and I, along with my co-counsel, Amelia DeGory, represent the petitioners in this case, United States. I will be addressing the first prong of RFRA on substantial burden. My colleague will be addressing the second on compelling interest and narrow tailoring. This accommodation imposes no substantial burden on the respondents primarily for two reasons. First, they face a purely administrative and therefore de minimis burden here. And second, the ACA creates a federal entitlement to this preventative coverage. And that entitlement, not the accommodation, is the cause of that coverage. RFRA only guards against substantial burdens, which immediately tells us that there are types of burdens which will not meet its threshold. The test for substantiality...
But you concede that their complicity concerns are sincere, right? You don't have any doubts about that?
That their concerns about complicity are sincere, yes, Your Honor.
So if that's true, they're stuck with either complying and violating their religious beliefs or not complying, in which case they have the huge financial penalties.
No,
How is that not a substantial burden?
Because we separate their sincerity from the substantiality. Questions of their sincerity, the reasonableness of their beliefs, we give them all due deference on that. We don't question whether it's right or wrong for them to believe what they do. But questions of substantiality go to how the law actually functions.
Substantiality questions are questions of fact or law.
They're questions of law, yes, Your Honor.
Did the court below ever engage in an analysis of substantiality, or did the court just presume that there was a substantial burden?
Referring to the Eighth Circuit?
Yes.
The Eighth Circuit did go into an analysis of substantiality and found that there was a substantial burden here, but every other circuit court that came to the question of substantiality agreed that there was no substantial burden here. Because when we look to what the law actually requires of them, not what they characterize it as, but how the law actually functions, it's only self-certification being asked of them, which is a very simple administrative opt-out procedure. And administrative burdens are de minimis, such as conscientious objectors can be forced to fill out a form proclaiming that they have a religious objection.
Isn't the completion of the form just a trigger that leads inevitably to that to which the respondents object?
No, Your Honor. The trigger is the ACA itself. That creates the federal entitlement for their female employees. Their employees are entitled to that preventative coverage whether or not their employer is going to provide it. All the accommodation does is clarify who's going to be shouldering that responsibility. It's assumed that it's going to be on the employer, but in this event that the employer has a religious objection, then all the accommodation does is shift that responsibility to the TPA.
But I mean, if their beliefs are sincere, that means they're not going to provide the coverage. And if they don't provide the coverage, they're going to get the big penalties. I don't understand how that's not what's going to happen. Don't you think that's what's going to happen? Or the only way you could say otherwise is that you think they're kidding about their sincerity.
Not at all, Your Honor. Their beliefs are sincere that
Okay, so if they're sincere, that means they won't provide the coverage. And if they don't provide the coverage, they get very significant penalties.
Or they take the accommodation. They don't have to provide the coverage here. That's what the accommodation allows them to do.
No, but their point is, given the complicity problem, they're sincere, so they're just going to not provide anything. Boom, you have the penalties, and they're big.
There is a separation between the sincerity and the substantiality, though, Your Honor. Their sincere beliefs don't entitle them to conclusions about how the law is functioning. So they think that the law is making them complicit, but when we study how the law actually works, we find that all this is just an opt-out mechanism. It's not making them responsible. They don't have to supply the contraceptives that they object to. They don't have to pay for it. They don't have to arrange it. All the opposite.
The government just hijacks their plan and uses it.
Not quite, Your Honor, because it's putting a responsibility on the TPA. It's not just their plan. They work with the TPA to provide health insurance to their employees. And so all of the things that they still want their employees to get, they still get. They still send their list of required coverage things that they want to their TPA. The TPA still provides the employers with all of that. All this does is shift the responsibility for providing specifically contraceptive coverage over to the TPA. So it's the TPA's job to do all of this. It's not their plan that's getting hijacked. It's the TPA that's simply being regulated here. Ultimately, their theory of how to read the first prong of RFRA reads the term substantial out of it entirely, because it gives them the power to say both what their beliefs are, which we already give them all deference on, but also demands deference on how the law functions, how they characterize the law. And if that's the case, then the word substantial does no work at all. It allows them to simply say that there is a substantial burden, and then we have to immediately go to strict scrutiny. But this is contradictory to the entire precedent of this court.
I'm not sure that's true. I mean, you could have an opt-out thing where they just opt out. That would be de minimis. It would still have potential complicity problems because someone else is going to provide the coverage. But if you say to them, hey, all you got to do is tell us you don't want to do it, that's the end of it. The TPA is not involved, and the government's completely in charge of coordinating the provision of these contraceptive services. That's the way it works. That would be de minimis. So I don't think the other side's position reads substantial out of it.
The other side's position does read substantial out of it, Your Honor, because ultimately they are saying that their characterization of the law should get deference. And that's not how this court has historically taken substantial burden.
Why can't you just treat them as you treat religious employers such as churches and the like? That would seem to satisfy Justice Sutton's position.
Mostly because that wouldn't further the compelling interest nearly as well. And on matters of compelling, and my colleague will be addressing compelling interest in greater detail, but in short, that more goes to compelling interest and how that wouldn't really help satisfy the objectives of the law nearly as well.
What about Hobby Lobby? Didn't Hobby Lobby essentially resolve the question of whether there was a substantial burden in a case like this, in this sort of situation?
No, Your Honor. Hobby Lobby specifically was a situation where the accommodation wasn't available. And in fact, the remedy in Hobby Lobby was to give the plaintiffs there the accommodation that we're here debating today. So in Hobby Lobby, they were just being forced, their only choice was provide the contraceptives or face the fines. But here the respondents have a third choice: provide the contraceptives, pay the fines, or take the accommodation, which removes them from all responsibility for even getting near the contraceptive coverage. They don't even have to enforce what the TPA does. All this form does is inform the TPA that they have legal obligations, but they're not the enforcers of that. They're not responsible for the TPA after they take this. So what the form does matters to whether or not we're going to say, as a matter of how the law functions, that they're responsible for this. What they're ultimately objecting to is third-party activity, Your Honor. Because...
Can I ask you a funny thing about this case? You know, we're used to these compelling interest, least restrictive means tests in applying the Constitution. But this is a statutory rule. And I'm sure the people that had if they had the votes for the ACA, they assuredly had the votes to modify RFRA to allow this very thing. Why shouldn't we say to you represent the government, just amend RFRA? I mean, effectively, this is a case that's a conflict between the ACA and RFRA, but unlike a constitutional case, you know, it's not that easy to amend the Constitution. Here, surely, it's a piece of cake to have an exemption in RFRA for just this kind of thing.
It's possible that RFRA could have been amended, but there's no need to amend RFRA for this situation because there isn't a substantial burden to be addressed here. What they're being faced with is just a simple administrative opt-out mechanism, and what the form does is distance them entirely from it. They don't have to face a substantial burden here. What they're ultimately objecting to is how the form is being used by their TPA or by the government. But this is a third-party objection. As this court held in Bowen v. Roy, where the Roys objected to the act of giving over their daughter's Social Security number to the government, this court held very specifically that because they were not objecting to the act of giving over the number, but to what the government did with the number, that could not form the basis of a substantial burden. And that's precisely what forms the basis of their objection, is not the literal act of reminding the TPA of their obligations, not the act of giving HHS the TPA's contact information. It's what the TPA will do, what the TPA's responsibilities are. But this is strictly precluded by Bowen. This type of reasoning has been categorically rejected.
But I mean, isn't the way the law works that this form, by signing this form, it becomes permission to provide the services to the exact employees listed? I mean, it's not precisely the same as that case.
No, Your Honor, it's not a permission form. It's Form 700 is very specifically not giving them permission. All it does is remind the TPA that they have legal responsibilities. It does not authorize the TPA to act on the behalf of the respondents, and it doesn't tell them to do anything on behalf of the respondents.
Isn't the employer essentially isolated once it either signs the form or sends the letter? It doesn't know what happens after that. Is that a fair characterization?
Legally, they are totally isolated from it, yes, Your Honor. They don't have to pay for anything, set up anything, have any contact with the TPA or the government on this matter. As soon as they sign the form, they are totally removed from the chain of events providing coverage.
They may be removed after they've done it, but whatever it is that happened or happens is the result of their having acted. Isn't that the case?
Not quite, Your Honor. There's a way to make an attenuated but-for argument here, but what's really happening is that the fact that they find themselves in a position to hinder federal law and a federal entitlement shouldn't be mistaken for them being the cause of the federal entitlement. Thank you.
Thank you.
Mr. Chief Justice, and may it please the Court, my name is Amelia DeGory, Counsel for the United States of America. The government has a compelling interest in equalizing women's access to preventive care and allowing religious nonprofits like the respondents to opt out of the contraceptive mandate while still ensuring their female employees and plan beneficiaries have seamless contraceptive coverage is the least restrictive means of advancing this compelling interest. Your Honors, women have unique health needs, and access to the full spectrum of FDA-approved contraceptives helps them to manage those needs. So from preventing unplanned pregnancies, to spacing out pregnancies, to managing chronic health conditions such as polycystic ovarian syndrome, to preventing ovarian cancer.
Let's say this is all right, and let's say it establishes a compelling interest. Why doesn't the government have the courage of its convictions and leave the religious groups alone, have a 1-800 number, get contraception here, and provide it through Medicare or Medicaid? That way you get political credit for it, you're establishing you really believe in it, and you leave the religious groups alone. It's perfect for everybody.
So if requiring women to call a 1-800 number in order to receive their contraceptives would go against what the departments found was the most effective way to increase access to preventive care, that is to remove the burdens that women would face in obtaining the care.
Is this your seamlessness point?
It is, Your Honor.
Okay, but that's really at odds with what your friend was just saying. I mean, the whole thing that makes it seamless is to use Little Sisters of the Poor's TPA, and that is what makes them feel they're complicit in it.
The coverage that the TPA provides is separate from the rest of their health insurance coverage, but the woman accesses it seamless with the rest of her coverage. And so the government's compelling interest in allowing full and equal access to preventive care means that the government is seeking to allow women to access that care without additional burdens or barriers. So by imposing a barrier saying you need to call a number or jump through additional hoops in order to access the care, the departments did the research that found that that would make people less likely to actually use it.
Well, what's the difference between there being no substantiality in completing the form and there being substantiality in having women call a 1-800 number or something of that nature? Why can't it be the same?
The difference, Your Honor, is that the respondents have chosen to provide health insurance, and so that comes with a set of legal responsibilities. women are seeking to access preventive care that they're entitled to under federal law. And when the departments researched how to make this access more effective, they found that removing barriers is the way to do that. So that's why seamlessness is so essential, because it's just a matter of human nature that if you put these additional roadblocks in the way of a woman receiving the preventive care, you're just going to make it less likely for her to use it. And when the Affordable Care Act was passed, part of the goal of the Affordable Care Act was to have more people accessing preventive care, such as a daily aspirin regimen, or in the case of women's health, a pap smear. But that also includes access to the most effective contraceptives, which is why it's so essential that those contraceptives be provided without adding additional barriers. I'd also like to address the existing exemptions to the contraceptive mandate and why they don't undermine.
Let me take you back to the earlier point. Who wants contraception provided by Little Sisters of the Poor anyway? I wouldn't be very trusting of that. I mean, it's just not the right group to be doing it. I mean, why, if they don't want to do it, they've already established that. Some of these groups may even incur the penalties, in which case you're back where you started. There's not even the services being provided. Just why wouldn't you want the government that created the program, that thinks it's really important, making sure the services are delivered? They're the group that really wants this to happen.
So if you're referring to a single-payer health plan, Your Honor, unfortunately the United States has an employer-based healthcare system. And so having a single-payer plan would require the government to completely...
Well, they have Medicare and Medicaid. Why couldn't one of those programs be expanded?
Because, Your Honor, those programs are administered by the states. So it would require the states to buy into having those programs be expanded, which it's my understanding that the Affordable Care Act already tried to do with things other than contraceptives, but just expanding how far above the poverty line one had to be in order to access it. So by providing it seamless with the employer's health insurance plan, it ensures that we're not going to be leaving these gaps in coverage that would be leaving women without the coverage that the Affordable Care Act has deemed so essential to women's health.
Let me ask you about this seamlessness matter. Would you describe physically what you mean by that? What exactly is it that makes it seamless? What is it that a female employee does for some other function or prescription that I think if we had a sense of what is happening physically, what is it that makes this seamless?
So by way of explanation, before the Affordable Care Act was passed, women were paying up to 68% more out of pocket than men for their preventive care. That meant that, for instance, if a woman wanted to get a copper IUD, which is one of the contraceptives that's at issue in this case, she might not be able to go to her network of doctors in order to get it. And if she did, she would have to pay out of pocket for it in order to receive it. So seamlessness means that you're going to your same network of doctors and receiving the care without having to sign up for additional paperwork or some additional program or pay directly out of pocket for a form of contraception that the federal government has said you are entitled to under law, the same way that you're entitled to yearly cholesterol screening or daily aspirin use. And that's why this is the least restrictive means, because it doesn't put additional barriers in a woman's path when she's seeking.
Why don't you give some? Why don't you turn to the alternative means that are suggested by opposing counsel, and tell us why, in your view, they're not less restrictive.
So I've already addressed the expansion of Medicaid. On page 30 of opposing counsel brief, they talk about having a free contraceptive-only plan available on the exchanges. So the healthcare exchanges are currently a creature of state regulation, state insurance. And so in order for the government to provide some kind of contraceptive-only plan, that plan wouldn't have a premium because contraceptives are cost-free under law. And also the current providers of plans on the exchanges aren't the government, they are private insurers. And so it would have the government going into a place of health insurance regulation that it currently isn't able to under statute. And it would also require women to sign up for an additional way of receiving their contraceptives, which would impose those additional hoops. Opposing counsel has also discussed just allowing them to be completely exempt from the contraceptive mandate, as Your Honor pointed out with regard to religious employers, and having women go out and get individual health care coverage that already exists under the state exchanges. There
In
already are.
exploring those alternatives, are we required to give HHS, or what is it, HSA or whatever it was, substantial deference, agency deference?
So I think that we have
The
to keep
alternatives that they explored, are we just to defer to them, or can we require you to come up with least intrusive means?
So it is the government's burden, that's for sure. And the departments did go into why these means were not less restrictive in the Federal Register. But here, there is no evidence that respondents' employees have any different health needs than the rest of the population of this country. So the government is showing by explanation that these purported less restrictive means are not actually less restrictive, because they would either impose burdens on the women receiving the care, which this court pointed out in Hobby Lobby is something that we need to keep in mind. And also, some of these purported less restrictive means would require the government to completely restructure the way that health insurance is delivered in this country. And while the government is already paying money in order to ensure that the respondents' female employees receive the coverage they're entitled to under law, it can't be the case that the government has to completely restructure the way that health insurance is provided. That would make least restrictive means, in effect, a moving target. Because for this set of respondents, it might be acceptable to have a single-payer government health insurance plan, but the next set of religious adherents, if we're going to buy into the complicity arguments, could come in and say, well, by just employing our employees, if they have access to this plan and they're going to be receiving contraceptive coverage, that is a substantial burden on our religious beliefs.
In least restrictive means inquiries, usually the existence of other exemptions is fatal. I mean, it's been fatal even in free exercise RFRA cases. You've got several here. One of them is for house of worship. It does seem strange to say yes to houses of worship in terms of the exemption, but not to pretty similar groups like some of the groups here.
So, Your Honor, this is not like Ocentro, where the government was providing a long-standing exemption for peyote, but then turned around and said, if your religious group wants to use ayahuasca, another hallucinogenic drug, you're not allowed, because we'd have to provide an exemption for everyone. Here, the existing exemption for instance, religious employers is based on the department's deep respect for the close relationship between a house of worship and its employees. So the government says, if you are working for a church or a convent, we are not going to require your employer to provide contraceptive coverage.
Yeah, but the line is, I mean, isn't one of these groups, like Little Sisters of the Poor, essentially a religious institution, but yet just goes out and does a secular thing, and that's what makes it ineligible for the exemption? Am I right about that?
I see my time has expired. May I briefly answer your question?
Oh, yes, of course.
So the difference is that Little Sisters of the Poor is a religious nonprofit. They are not a house of worship, so they would not fall into the narrow exemption based on the tax code that is easy to apply.
But it's just because they do something else.
It's because they are a nonprofit with a religious affiliation. So, thank you.
It's more than an affiliation, right?
They're a nonprofit who holds themselves out as being a religious nonprofit. And that makes them different from a house of worship, which is a church or its integrated auxiliary.
Thank you.
Mr. Chief Justice, and may it please the court. My name is Hope Staneski, and along with my co-counsel Leah Brenner, I represent the respondents, the Christian nonprofits CNS Ministries and Heartland Christian College. This court should affirm the preliminary injunction because the so-called accommodation to the contraceptive mandate is no such thing, and therefore it is invalid under RFRA.
What is the substantial burden here? Is filling out the form the substantial burden? What's the threshold question that has to be answered to determine whether there's a substantial burden?
Your Honor, RFRA does not define what counts as a substantial burden on religious exercise, but this court has articulated that a substantial burden exists when government action coerces or pressures a religious adherent to violate a sincerely held religious belief.
But in this case, what is the substantial burden? Are you saying that it's a burden for your clients to complete the forms or send in the letter?
Yes, Your Honor, but the accommodation also forces us to be complicit in the provision of abortion-causing drugs in a second way as well. So in addition to the fact that self-certifying triggers the provision of abortion-causing drugs, the accommodation also enlists respondents' employer
Doesn't the accommodation just trigger the operation of the law? Your clients doesn't have to do anything because after they complete the form or submit the letter, they're done with it. They wash their hands of it, so to speak, don't they?
No, Your Honor, the accommodation is more than an opt-out. The accommodation requires respondents to affirmatively provide the information of their TPA to the government or to affirmatively tell the TPA that it must provide this contraceptive coverage. Now, that's more than the opt-out that a conscientious objector must do in order to be relieved from the draft, because a conscientious objector merely raises his hand and says, I do not want to participate.
Well, would that be illegal if they had to fill out a form and say exactly who they are and what their social security number is, and therefore the person drafted is not going to be that person?
Your Honor,
Wouldn't it start to look like this particular program?
It might be more of a burden. And now the accommodation burden...
Would that be illegal, though? So it's conscientious objector. They've now got to fill out a form. They put their name, their social security number, and essentially saying, not me, when it comes to the draft, i.e. somebody else.
If the conscientious objector had to designate the replacement, then yes, this case would be analogous and it would be invalid under RFRA. The difference between the form that a conscientious objector might fill out to opt out of the draft and the self-certification in this case is that the conscientious objector's form merely makes it more difficult for the conscientious objector to practice his or her religious belief.
But in this case, to keep the analogy, I don't think Little Sisters of the Poor has to designate who's doing it.
Your Honor, ESBA Form 700 must be delivered directly to the TPA. That's one form of self-certification, in which case the nonprofit is instructing the TPA to provide this coverage. The second form of self-certification is to provide the TPA's information to the government.
But isn't the point of the form simply notification that this organization does not countenance contraception and the like? That's it. And then it simply is notifying the TPA or whomever that it now has to take over. In fact, women and the other employers are pretty much told that the employer has nothing to do with this. Isn't that correct?
That's correct, Your Honor, but without the form, then the TPA would not know to provide this coverage. And without providing the TPA's information to the government in the alternative notice, then the government would not be able to instruct the TPA to provide this coverage. And that's the difference here. Now, that's different from Bowen v. Roy, which the government relies on. In Bowen, this court did not reach the question of whether providing the Social Security number to the government was a burden on religion. It merely reached the question that when the government already had possession of the Social Security number, whatever the government did was purely third-party action. Now,
do you know of any other cases where simply concluding or where there's a similar minimal administrative notification procedure has been found to be a substantial burden on religion?
I do not, Your Honor, but in this case, the opt-out self-certification form is not the only burden on respondents' religious exercise. The accommodation also makes use of their existing employer-provided framework as a conduit for the delivery of these abortion-causing drugs. Now, the Affordable Care Act deliberately made use of the existing employer-provided insurance system in this country. Yet now the government argues with a mere form the employer here is relieved of any participation, but that's just not so. The respondents in this case select a TPA, provide all of their employees' information to a TPA, and set up an employer-provided insurance framework.
But that's just because they're self-insured. If they weren't self-insured, then they wouldn't have to designate a TPA. Is that right?
That's correct, Your Honor, but the argument would be the same if they contracted with an insurance issuer. Because here, the respondents are setting up a ready-made avenue for the delivery of contraceptive drugs that the government is enlisting, and that is using rent scheme. Opt-out does not relieve respondents of the ongoing participation in maintaining their employer-provided insurance. Now, the government argues that this is a function of...
So what exactly would work?
Your Honor, the current accommodation as it stands by using the employer-provided insurance framework would be a burden even if the notice changed. The government would have to explore...
Well, no, I mean, just say the government's all ears. Just tell us what you'd like.
Providing insurance through Medicare or Medicaid, as you suggested, providing insurance on the exchanges.
But that would still require an opt-out and probably still require, a written something. Is that okay? Just a written something that says, we're not doing this, you're on your own here.
Yes, Your Honor.
That would work?
The difference between a written...
But that would work?
Yes.
So I just don't, why is that any less complicit? I guess, I know it's not our job to figure out these issues of faith, but I'm struck by why it's that much of a difference. Because it seems to me nothing's going to change. The same thing's going to happen, which is you're still going to have the government one way or another providing these services. And it will have been triggered, to use your term, by an action of the faith-based group.
Your Honor, the affirmative provision of the TPA's information is the trigger here, and that means it is impossible for the respondents to maintain insurance consistently with their belief. Now, a mere opt-out form, more analogous to what a conscientious objector must fill out, would merely make it more difficult for the respondents to provide insurance consistently with their belief. In this case, because the current function of the accommodation makes respondents complicit, there's no way for them to escape that complicity. But filling out a form to opt out, while it would still be a burden, would not make it impossible for respondents to comply with their belief.
I'm still troubled and confused about the whole complicity argument, because if the employer has wiped its hands of it once it turns in the form, the employer doesn't even know what employees have taken advantage of the contraception mandate. So how is there complicity?
Well,
At some point, doesn't it become too attenuated to be complicity?
Justice Marbley, this court held in Hobby Lobby that many steps or attenuation between the ultimate violation of the belief and the religious adherence action is not grounds to deny a finding of substantial burden.
But in Hobby Lobby, we also found that the opt-out provision was a way to alleviate the substantial burden. So it's a double-edged sword for you, isn't it?
Yeah, Hobby Lobby seems to suggest you lose. That's what they're hinting at.
Well, Your Honor, Hobby Lobby affirms this court's holding in Thomas that the reasonableness or accuracy of a religious belief is not to be questioned by either a government agency or this court.
But we aren't questioning the reasonableness. Don't we still have to make a substantiality determination? And we can do that, I would presume, without questioning the reasonableness or the legitimacy of any of your religious tenets.
That's correct, Your Honor. So the substantiality determination that this court would make would depend on the coercion or pressure that the government is placing on religious adherents to violate their belief. In this case, the coercion comes in the form of fines of $100 per affected individual per day.
But you get around that fine if you submit the form. So you either submit the form or you incur a penalty. But isn't that always the case when you're trying to enforce any law? There are consequences.
Your Honor, there are consequences, but in this case, that consequence substantially burdens respondents' religious exercise. Now, the government characterizes what the respondents believe here as a misunderstanding of the law and contend that it's really just the Affordable Care Act that imposes these obligations. That's not mutually exclusive with the fact that the Affordable Care Act requires ongoing participation by the respondents. And that's the burden here. That participation makes respondents complicit in the provision of abortion-causing drugs. And complicity is a total violation of respondents' belief in the sanctity of life. That's different than cases in which the government merely makes it more difficult for respondents or religious adherents to practice their belief. For example, in the 11th Circuit case Midrash Savardi, the town of Surfside zoning regulations prohibited synagogues and houses of worship from the business center. That meant that the congregants at the synagogue had to walk further to get to their religious services. Now, the congregants did not use cars on the Sabbath, so the walk was a burden and did make it more difficult for them to practice their religion. The court found that that merely made it more difficult, but did not eliminate their ability to practice consistently with their faith.
I'm struck by something in this record that you appear to agree or have agreed in the district court with opposing counsel that there are no questions of fact here. Is that right?
That's correct, Your Honor. And
These are all questions of law?
whether a substantial burden exists is a question of law for this court to objectively decide. In doing so, it must take the respondent's belief that they are complicit and the accommodation requires them to be complicit, as the respondents have asserted it here.
I would have thought you'd have a stake in having some sort of evidentiary hearing in the district court on this question, where a district court might have had a basis, even stronger basis than it had, by asserting it as a question of law. But you weren't interested in that, apparently.
Your Honor, I see my time has expired. May I respond?
Please.
Your Honor, a hearing in the district court to develop the record would be helpful for the strict scrutiny prong of the RFRA analysis. But in this case, there is a substantial burden as a matter of law, so we must proceed to that prong.
Thanks very much.
Mr. Chief Justice, and may it please the court, my name is Leah Brenner, counsel for respondents, CNS International Ministries and Heartland Christian College. Today, I will address the strict scrutiny prong. Now, once a substantial burden is established here, this court must invalidate the mandate as applied to respondents if it fails RFRA's strict scrutiny analysis. And it does fail strict scrutiny. There is no compelling governmental interest, and the current process is not the least restrictive means of achieving that interest. As such, CNS and HCC are entitled to an exemption from the mandate. When government substantially burdens religious exercise, as here, the burdened party is
How can you say
entitled-
there's not a compelling interest? I mean, it seems to me they've got quite a bit on that front.
Well, Your Honor, compelling interest is an inquiry that is narrow in scope. It relates to the person who has challenged governmental action. And CNS and, this court's decisions in O Centro and in Hobby Lobby do support that narrow contouring of compelling interest. And so here,
But the people here are the women who worked for your client. And it seems to me they're pretty well established why they're doing this.
But, Your Honor, the compelling interest here in women's health and equality that the government has asserted simply isn't enough to meet RFRA's strict and narrowly tailored compelling interest inquiry. Now,
Prophylactic medicine for women is not a compelling interest?
well, Your Honor, the government must show a compelling interest in requiring religious employers like CNS and HCC to act in a way that provides this coverage to their employees.
What are the least restrictive, what are some lesser restrictive measures? We talked about it with opposing counsel. What would you have us do?
Your Honor, there are numerous options that would be less restrictive than the current
Such
process.
as?
And that would be, for instance, the government could provide these abortifacients separately from the plans, or since the government asserts this interest in seamlessness, which I will discuss more, it could still meet that interest by providing entire, comprehensive alternative health plans to women, which would only require for those women to complete the same process
But that would be at a cost to the taxpayer, so shift the burden then to the taxpayer.
Well, Your Honor, there are numerous ways that this could be worked out, and ultimately it is not CNS and HCC's obligation to show that these less restrictive means would be feasible. In fact, it is the government's burden to show that it has considered other options and that those options are not feasible, and the government has not met that burden.
I want to do more least restrictive means, but I want to understand one thing on compelling interest. Let's assume there are some employees, some women who would like access to these services, and when we think about compelling interest, do we focus on those women, or do we focus on what's happening to the employer in terms of signing the form? Which do we focus on? Or do we focus on both, or?
Your Honor, we focus on the person who has challenged the governmental action. So while there is...
it has to be a compelling interest in terms of, quote, coercing the employer to sign the form.
Yes, Your Honor, and here the government is asserting
that just seems to load the deck. I mean, why wouldn't the government be allowed to focus on the women that they want to get this insurance?
Well, Your Honor, the women are a necessary component to that inquiry, but it's not as broad as the government has an interest in women's health care, therefore it can require employers to include this.
I thought it was that way, and that you just had to fight over least restrictive means.
Your Honor, this court must decide whether the government has a compelling interest in requiring religious nonprofits to administer this coverage or to participate in the administration of this coverage.
How much deference do we give to HRSA because they're the ones who came up with the least restrictive means? How much deference do we give to them?
Your Honor, while HRSA does get some deference in this case in terms of the least restrictive means that it has articulated, the government still must show that it has considered other options, that those options are unworkable, and that is the burden that the government has not met here. This was notice and comment rulemaking, and the final rule that was accepted by the government was unresponsive to those comments.
How would you be able to show any of this without some presentation of evidence? There was no evidence apparently at all submitted to the district court. Is that right? Am I right on that?
That's correct, Your Honor.
Yeah. I mean, not even in the form of affidavits, right?
There were affidavits from Mr. Sharp and a couple other employees, but that was it, Your Honor.
Yeah. So how would you show, or how would you be able to question the judgment of the administrative agency, of the agency here? That is, why aren't we required to accept their judgment on what's restrictive or seamless or whatever?
Well, Your Honor, that's because the district court and the lower courts have ruled that there were less restrictive means that the government should have considered and did not show to be unworkable.
And how would the district court have come to that conclusion?
Because, Your Honor, at the facts that were presented in the record, it decided that it was clear that there were other options that the government...
And what facts were those? I thought we had no fact-finding.
Your Honor, simply the more logical facts that there are less restrictive means, such as I've proposed, in offering comprehensive health insurance plans to women or offering abortifacient-only plans for women that the government simply did not consider in this case.
I just don't understand how any of these decisions can be made by a district court, much less by us, without some sort of evidentiary proceeding. But you went along with this from the beginning. You accepted, you stipulated with the government on whatever facts there were.
That's correct, Your Honor.
Do we know that the government didn't consider them and rejected them? Do we know that in the absence of fact-finding below?
Your Honor, there's simply no evidence that the government did consider them.
Or didn't?
Did
Either
or did
way.
not. Correct, Your
Okay.
Honor. Now,
Would it satisfy you for us to send it back to the district court for fact-finding?
no, Your Honor, because in this case, it is clear that there are less restrictive means that the government could have considered, and it must consider those, and as such, CNS and HCC must...
How is it clear that there were less restrictive means if there was no fact-finding?
Your Honor, simply because the current process because we don't know, and that is the test that RFRA requires. RFRA requires that if the government has not articulated these less restrictive means and has not offered its evidence, that this court must invalidate the mandate as it applies to respondents.
How does this work? I mean, you've identified 4 or 5 less restrictive means, so it goes back, you win, the government says, okay, we'll try number 5. You sue again, and you're going to say, well, there's still 4 left. And then we just keep doing this? When does this end?
Well,
I mean, there's always something else you can do, don't you think?
Your Honor, at some point, the least restrictive means test will do some work. If the government has truly shown that it has a compelling interest and that the current process that it is using is the least restrictive means, then at some point, the person challenging the government's action would fail under this test, but that is not the case that is before you today.
Is least restrictive means a question of law or a question of fact?
Your Honor, it is a question of law. However, the government must show that it has considered these other options.
And how does it show that? Or how did it show it? Or how could it have shown it?
Your Honor, it could have shown it when it adopted the mandate from her HRSA as it had considered the IOM report and numerous other pieces of fact that were in the record of this case. And the government did not show that it had done that. The government could have done this in a variety of ways. Through the notice and comment rulemaking, it could have allowed religious nonprofits to have a so-called seat at the table and could have addressed the religious nonprofits' specific concerns. And instead, the government remained silent on those concerns.
What if we decided that religious nonprofits should be treated as religious organizations? Would that be satisfactory?
That would be satisfactory, Your Honor. And in fact...
And if we did that, then why doesn't the exception subsume the rule?
Your Honor, because it would simply be a small expansion of the current religious exemption. Now, the government's rationale in that exemption is that religious employers and their integrated auxiliaries are more likely than other employers to employ individuals of the same faith. But in reality, CNS and HCC are quite similarly situated to an integrated auxiliary. The only difference is that an integrated auxiliary is associated with a church, and CNS...
Yeah, but you got to draw lines, right? I mean, you have to confess, you have to draw lines, right?
That's correct, Your Honor. The government does need to draw lines, but couple that exemption with the current exemption for grandfathered plans. Now, those plans might be perpetual. There's no set time at which they must expire. And so the government's real asserted compelling...
But isn't the way this works is they do change pretty quickly? Haven't the number of these plans been going down?
Your Honor, the government has been, the number has been going down. However, they could technically exist in perpetuity. At the time that Hobby Lobby was decided, an estimated 1/3 of individuals with employer-sponsored health insurance those plans were covered by the grandfathered exemption. Now, take these exemptions together. Some of them are broad, some of them are narrow, and in each the government has drawn a line. It has made a decision, which just shows the arbitrariness. Truly compelling interests are not riddled with these exemptions. The heart of the government's asserted compelling interest argument, to go back to something that Justice Sutton mentioned earlier, is really simply administrative. That's because, as I've discussed, there are less restrictive ways of achieving this health and women's equality, but the government, I see my time has expired.
No, go ahead.
But the government has deemed them unworkable because of the process the government must go through. Therefore, this court should hold that the preliminary injunction should be affirmed. Thank you.
You've reserved some time for rebuttal?
Yes, Your Honor.
Happy to hear you now.
Mr. Chief Justice, may it please the court, I'm going to address the complicity arguments that were leveled by opposing counsel. And in fact, what they've done is bitten the bullet on complicity by arguing that complicity gets to mean whatever it is they say it means. But this cannot be the case. This cannot be the right reading of RFRA because, as I mentioned earlier, that means that they have the power to both declare their beliefs and how the law operates.
Well, no, the government has the option of challenging the sincerity of their beliefs, but you didn't do that here. You accepted the sincerity of their beliefs, which at that point, it seems to me they're allowed to say how they work.
Not how the law works, Your Honor.
Complicity is about faith.
Complicity, worries about complicity are about faith. Whether the law makes them complicit is a question of how the law functions. Pardon me, is a question of how the law functions, Your Honor. And how this law functions isn't subject to their to their religious beliefs. And so we have to keep looking at the particularity of what's required of them, not their characterization here. Complicity has to do work somewhere, and it needs to be here because there has to be a line drawn somewhere. Because if complicity just means whatever they say it means, if they get to raise a substantial burden whenever they want, the first prong of RFRA disappears. And this court has found complicity grounds in other cases, such as Thomas v. Review Board, where there's a very direct connection between where he was making tank turrets.
What do we do about their view? Their view is by signing the form, doing everything you say, they aren't complicit in terminating pregnancies, which to them are, babies. That's what they think. Where do we not consider that when it comes to the word substantial? I agree with you, substantial is a legal term. It's for us to interpret, but if that's their sincere belief, where do we say that's not substantial?
Where they start interpreting how the law functions. So where they say that the law is forcing them to be a cause of something, we have to look objectively to what, I see my time's expired, may I briefly finish?
No, please.
Where they say that the law is
We're not
forcing...
fanatics.
Where they say the law is forcing them to do something, it's for us to figure out whether or not the law is forcing them to do that. And here it is not.
Is it satisfactory that we begin the substantiality analysis at the act that they have to perform, that is, completion of the form?
Yes, that is where the substantial, that's where the burden being alleged lies, is at the form and nowhere else. Thank you.
Thank you. We'll reserve decision, and we are adjourned.
All rise.
be seated. We'll each have an opportunity to comment in a moment after we announce the decision, which I preface simply by saying that it was not as easy as it may appear from the fact that we were in there deliberating for so short a time. It's just that we're able to make decisions. We're in the making of decision business.
There's a reception.
We're in the business of making decisions, so we don't. So we were able to do that, and we actually did deliberate. My understanding is that you wish to know what team won, and as far as this panel is concerned, the panel of for the petitioners wins. That's Ethan Wright and Amelia DeGory. And we're also called upon to decide the best single oralist, and we've decided that is Amelia DeGory. All right, my colleagues I know will wish to make some general comments on the arguments and hope they're helpful.
I didn't leave anything in the other room. You guys, I kept throwing it faster, and then you'd hit that out of the park. I throw it a little faster. I tried sliders. I slide curveballs. I couldn't come up with anything else. So I have to say I was really impressed with all four of you. To me, there's a lot of ways to measure a great advocate, but one of the most important is for the advocate never to lose control of the argument, no matter what's happening or how good or bad or hard or easy the questions are. And I was just really impressed that all four of you kept control of the argument. It just seemed there was never a time where you didn't know where it should be, you didn't know how to take it back to where it should be. So that, to me, was quite impressive. I should say, by the way, I thought the briefs were very good. Not all the moot court competitions are we supposed to grade the briefs as we did this time, and I was really impressed by that. It turns out that's about 80 to 90% of winning, so you should be more thrilled about that than anything we're saying about your oral advocacy. The best advice I ever got on oral advocacy, Dean Levy will appreciate this, it came from Justice Powell's secretary, Sally. It was very short. Answer the questions, and it's deceptively hard, and it's not just important to answer them, it's really important to make it seem like you're trying to answer them. That's really what judges want to see, and you'll see, when you see judges get upset, it's about advocates that are playing games and not willing to listen to what the judges are saying, not willing to take on the difficult point they're raising, and I thought you guys were just really terrific at that. Now, usually when you do these kind of comments, one of the judges will say something like this: well, you guys are so good. I wish we had you at our court all the time. You're better than a lot of the advocates we get. And I've heard this so many times, I've started to just not take it that seriously, we're just trying to be nice. Well, I'm gonna prove it today. So get a pen. We still could revoke your awards. So get a pen. And I have a phone number to write down. It's 513-564-7000, and the name is Ken Loomis that you need to ask for. And you have to say, Judge Sutton, this always works really well, asked me to call. And so as soon as you pass the bar, you have to graduate and then pass the bar, call him and come down and argue a case. And so I'm now proving it. I'm not just saying you're as good as these other advocates. I'm trying to get you to come to Cincinnati to argue cases in front of us, because we would be very grateful and you'd really represent the clients well. So thank you. I really was impressed.
I will echo Justice Sutton's comments.
Yes, let's keep talking that way.
You all he grades my paper, so but I thought that you all were excellent, and I have one maxim for oral argument, and that is that understand that judges' questions are an opportunity to persuade. And, you know, you would be surprised at the number of lawyers and advocates who don't understand that. I thought that all of you, all four of you, did a wonderful job of that. Hope, at one point, I was almost chuckling because we were asking you so many questions. I was saying, you know, she barely has an opportunity to answer. But what I thought was so effective about your argument was that you would pivot from the answer that you gave to your next point. You never missed a beat, and you know it made your argument, I thought, very persuasive. I thought that, Ethan, you did likewise, because we were peppering the two of you with probably a few more questions than we did with the other two, and you never lost your poise, and that's a skill. I think that the most effective thing that you can do as an oralist is to be able to integrate those questions and the answers into your next point and maintain cadence. There's a certain flow that you get from maintaining the cadence of your argument. And so one other thing that I want to comment on is how well prepared you were with an understanding, not just of the cases, but of the substance of your case. Because when we started talking about the development of the factual record, that was not necessary. That was more like a policy issue. And Chief Justice Cabrenis and I, well, he was on the district court. I am on the district court. So a development of a factual record is vitally important to us.
We believe in facts.
Yeah, we believe in facts. And we want you to develop the type of objective truths that we require in court. And so nobody seemed put off by it. You didn't say, well, no.
I was a little put off.
This is not a...
When are they going to keep going on with these facts and the district court judge stuff? Oh, my.
Facts. Veritas. But I thought that you all handled those questions very well, because you know the questions that we're going to ask about the cases. You can prepare for that. What determines how well you will do at oral argument often is how well you handle the unexpected and the unanticipated. And you only handle those well if you understand the problem, not just a prepared, but you have an understanding of it. So I want to commend all of you for the level of preparation and the level of understanding that you brought to this, because I think that lawyers who argue before the Supreme Court have to understand their case, not just know what the jurisprudence says or what their clients need, but to have a fundamental understanding of the policy behind the law and behind your argument. So again, I want to commend you on a job exceptionally well done by all four.
Yes, I'd like to essentially underscore what both of my colleagues have said, and perhaps put it in a slightly different way, but it's exactly the same point. Each of you showed a command of the subject matter, which was really quite remarkable, in the sense that, which I think explains why, as Judge Sutton said, none of you lost the thread. The reason you didn't lose the thread is that you were at home with the material, and you didn't do what often happens, not only in moot courts, but in real oral arguments. None of you conveyed the impression that we were disrupting you. We were disrupting your chain of thought. That's very important and a great skill, frankly, which I admire greatly in lawyers. Often it takes the form of, I'm so glad you asked that question, Judge. Or give the impression that you're glad that the question was asked, even if you're not at all glad that it was asked. It's very important, I think, because in each case, each of you were sufficiently at home with the material, which is proved by your excellent briefs. And I would just have a footnote on that. having gone to each of us has gone to quite a few moot courts in our time, I think the fact that you were working from a real case with a real record, with the occasional bracketed, omitted paragraph by Professor, whoever he is, I'm sure he's here, whoever omitted those paragraphs. Yeah, I kept on wondering, why did he omit that paragraph? So I think that's helpful, that it was a real case and you actually were able to get into it, and you were each at home. That's the key point, which I think the three of us have tried to say in different ways. The reason you don't lose control of the argument or your chain of thought is precisely that you know this case. I mean, none of this is really startling, or at least you didn't give the impression that you were startled by any of it. You actually followed the questions. That's remarkable in itself, which is, again, more or less saying the same thing in a different way. You never gave the impression that you were troubled, bothered, even if you were bothered. That's very important. I mean, you had command of the situation, and that's another word for poise, I guess. But all of it, I think, grounded in the fact that you clearly had command of the legal substance and of the record, which is great. Great. Thanks very much.
Thank you.
We'd like to thank everyone for coming tonight, and a big thanks to all three of our justices, Judge Marbley, Judge Cabrenis, and Judge Sutton. Thank you so much.